everyone. My name's Kate Holliday. I'm the operations manager here. Today, we're going to be doing a webinar over just best legal practices for hiring and managing. I'm joined today with Mallory Farrar. She's one of our associates. I love her to death. So super happy to get some insight from her and listen to her share a little bit of her knowledge.
Thank you, Kate, for the very, very kind introduction. Okay, so as Kate noted, we're going to be going over some legal implications around your hiring strategies and the way that you run your employment program. First of all, thank you all for joining us. We really love having this chance to, kind of interact with you in a face-to-face type way, considering we're all spread out across the country from one another. So thank you for joining. But yeah, I think, your employment policy, your employment program, that is the backbone of your business. When we think about your business and what the value to it is, you're thinking about your brand, your revenues, your client base, but your employees are what make all of that possible for you. So we have to be sure that when you're thinking through employment strategies, that you're thinking through it from the standpoint of a lawyer and to the extent you possibly can. Because no matter how wonderful somebody may be, there might be problems down the road. And that's just the reality of it. So we put together a brief presentation for you just to go over a few big ticket items that you should always be considering when you're looking to onboard somebody or just looking to deal with different employment related issues. Okay, so it matters, right? It matters because every employee operating underneath your structure is a liability to you. They're also the ones bringing in the revenues, but they are also a liability to you. And not just from the practice of aesthetic medicine or aesthetic nursing standpoint, but also from an employment law standpoint and a personal injury type standpoint. We always have to remember that we're all employees of someone, right? So we all have rights just as much as our employers do. So it's just important, especially in the healthcare space, because we're doing clinical things. It's really important that you're very careful in recruiting, selecting, and ultimately hiring any employee that you bring on to do clinical services in particular. Although people doing other services, administrative, bookkeeping, et cetera, are equally as important. So these kind of concepts apply across the board. Vetting and hiring. We all know what it's like when you're trying to find good work. You have all these candidates coming in the door. None of them are really hitting the marks. None of them really feel like the one you're looking for. And then finally, you find the perfect candidate. They pass their background checks. They have great references. They're friendly. They're personable. They have, other people who can attest to their abilities and how great they are to work with. And so you just say, well, this is perfect. This is great. Let's go ahead and get to work. You can start on Monday. We'll give you your onboarding materials then. We'll make sure that you have your correct badges, et cetera, and just start working from there. That is one of the worst steps you can take as a first step. And I say this because when you find somebody who is that special candidate, more than likely they're looking at you as that special employer. It's a two-way street here. So you want to be sure that you have a contract between you that clearly lays out what everyone's rights are, what the employee's duties are, who they're going to report to, what their pay is going to be, all of those sorts of things, so that in the event there's ever trouble down the road, you have a document that says, look, here are the rules. We both signed them. Sorry. You'd be surprised at how many clients we do have come in who have issues, whether it's with previous employees or current employees. And we always ask, well, can I see a copy of the agreement? And I would say more often than not, there isn't one. So whether you hire somebody on as a W-2 employee or an independent contractor, a 1099, you should always still have a written agreement in place between the two of you that, again, outlines roles and responsibilities, rights and obligations. You should make sure that that is fully signed, meaning both you have signed it and the employee has signed it. And make sure that you have that document in hand before they set foot in your space to start working. Verifying licensure. So with respect to clinical employees, this is critical. Somebody can come to you and show you a board issued license in hand and a certificate of training and their diploma, and you can take that on good faith. But what you really should be doing, no matter how fantastic this candidate is going online to your state's regulatory board websites, whether that be for estheticians, whether that be the Board of Medicine, Board of Nursing. Go to those websites. They all have a license verification tool where you can plug in somebody's name and pull up their history, and it'll tell you if they're currently licensed, if they have restrictions on their license. For example, not all NPs and PAs can prescribe. Some of them have to take extra steps to have that authority. Those are the kinds of things you might see on a licensure report. In addition to seeing past disciplinary actions or actions where the board has taken some sort of formal step against someone's license. Now, that does not mean that they are, that they're guilty of having done something wrong, or like there are lots of ways somebody can have something pop up on their licensure report. But the most important thing is that you know it's there and you can approach the candidate and open that line of conversation up to find out what that's about and make your own decisions on how you'd like to proceed. In addition to verifying licensure when you're onboarding, you want to be sure that you check this throughout the year, maybe just once a year, maybe twice a year, but licenses expire. If one of your employees comes under a board investigation and their license is suspended, you're not going to necessarily know that. It's not their obligation to tell you that necessarily. Your contract will say that. If we draft a contract for you, for example, it's going to say you have to let us, the employer, know if anything happens with your license. You've got to let us know right away. That doesn't mean that they're going to follow that rule in the event that they're under investigation, they're freaked out, they don't want to also lose their job. So it's just good to keep tabs on the licensure for those individuals as if you didn't have the option to ask them. Just do what you can within your own power to vet their license. That's really important. Another thing that we see a lot of, especially in the medical aesthetics and regenerative medicine field, are, employees leaving one employer and going to another where there's already fierce competition. I think we all know that in this particular space of the healthcare industry, there is a lot of competition, as there should be. It's a great space to be in. But with that said, with that competition comes a lot of possessiveness in a way over what someone has invested in an employee. So for example, something we commonly see, we will have like an RN injector has been working for this particular practice for 2 years. They trained her, they got her certified, she's been working with their clients, they promote her in their social media, and she is amazing. Everybody loves her. Well, she decides she wants to leave that job and come to you because you have an opening and y'all met at, some social event and got to talking and realized you're in the same field. Well, you need to be sure that the agreement she has with her employer, the current employer, if she has an agreement, doesn't prohibit her from working for you. That's a non-competition covenant. We've all heard of those. And that is the kind of covenant, which is just a promise that you would put in a contract that says, after we end our relationship, I promise for, a term of 1 year, not to provide these same services to any other business that provides these services within a 15-mile radius. I'm just throwing those numbers out there. Some of these non-competes are much broader, some of them are more limited. But if you have that happen, and I'll go ahead and tell you, your employees are most likely not going to think about that. They're most likely not going to think about that at all. I've seen a situation where the employee and the employer are very happy together, and then suddenly they get a cease and desist letter from a previous employer saying, hey, your new RN injector promised us that for a year after she left, she wouldn't provide these same services within, this 15-mile radius. Well, it's only been 6 months and you're 3 blocks down the street. She can't do that. And what happens in those cases is either that other employer will try to force you to get rid of that RN injector, or they'll offer you a buyout, which could be anywhere from $5,000 to 80 grand. Essentially, employers want to, and this works for your benefit too, on the other side of it. This is why you might want, non-compete agreements or provisions in your agreements. You're investing time in these individuals. You're investing training. Every client that they work on of yours, they get to know that person. They get to like that person's style. When that person leaves, those clients are free to go with them. Now, you can require that employee to not actively solicit and recruit clients, but ultimately clients have freedom of choice. So whether you're hiring somebody and you're worried about a relationship they may have with the previous employer, or whether it's just a part of your general employment policy and practices that you put non-compete type limitations in your agreements. It is a very, very strong, strong tool. So that's the thing about a contract. Contracts don't matter until somebody wants to fight about them. When you go into court to fight over a contract, something like a non-compete, courts don't generally like them, but they will uphold them, even if it seems incredibly unfair. So just be very careful that you make sure your potential employee is not subject to such a thing. Okay, scope of practice. So, and we all know that this is a murky area and that there's a lot of confusing information or just conflicting information. Part of that is because all 50 states have different laws. A big part of that is that as this field continues to burgeon, there are going to be more laws applicable to it. The government pays attention when an industry really starts to boom, and this industry has been booming for a while. So the more success you have, the more government scrutiny is likely. Because of that, you want to be sure that everyone you are hiring or that you have on staff is appropriately licensed, trained, and credentialed to perform the services they're performing. So, for example, we use estheticians in this slide. In a lot of states, estheticians are not permitted to microneedle. Does that mean that everybody's following that rule? Usually not, but it is still a rule. In some states, like Colorado, for example, estheticians can actually perform a lot of services that would be considered nursing or medical, provided a physician has approved that and is overseeing them. But the main point there is not all licenses are created equal, of course. Certain things that an RN can do, an esthetician may not do. And the boards will hone in on that. If you get inspected or somebody files a complaint, the boards will hone in on those kinds of things and ding you for them. Another good example would be lasers. In some states, like Georgia, for example, you have to get a special type of laser licensure. It's not that difficult to get. Most people can obtain it, but it's a requirement to fire a laser. In certain states, only physicians can use lasers. In some states, anybody can as long as they're properly supervised. But the bottom line there is that you need to be sure that to know what your state requires and what your state limits, because scope of practice is very, very important. And that extends all the way to the arrangements between your practitioners. So, for example, in states where NPs and PAs don't have full practice authority, they have to have a supervision arrangement with a physician. You want to make sure that's in place, that there is an agreement documenting that, and that everybody's upholding the steps in that agreement that they're supposed to uphold. That's really, really important. Okay, independent contractor or W-2 employee. This is a really important one, primarily because it involves, the IRS and the federal government in an area that they really, really pay attention to and regulate heavily, and that is, of course, employment law. Sometimes it's easier to hire somebody on as an independent contractor. It's less of a burden on the tax side for you. They have a lot more control over what they're doing. It's more of a hands-off, let's see if we like each other and go from there kind of arrangement. And that's fine. And some people maintain those relationships throughout their entire working careers, and that works. Some people want to have W-2 employees, whether that's because it just fits your overall structure better, or that, whether you have a list of candidates you want to hire, but every one of them is saying, I want all of these benefits, but, I'm entitled to, and I want to be a W-2 employee for that purpose. It's really a business decision on your end how you classify, but you have to be positive that you classify very, very carefully. And by that, I mean the distinction between how an individual is taxed as a W-2 employee versus how an individual is taxed as a 1099 is huge. So things that the government or courts will look at when trying to decide whether you've classified somebody properly is, do they bring their own tools? Do they control their own schedules? Do you direct the manner in which they work? If all of the answers of it, if they do bring their own tools, they have their own schedules, and you're kind of hands off with how they work, in most cases, they're an independent contractor. There are more factors than that, just giving some examples here. But in the end, you just want to be sure that the IRS is never able to come back to you and say, you misclassified this employee, and now you're going to owe all these penalties and fines and various taxes. It becomes a very big headache, and it takes a long time to get through those types of issues. And then also, on that same thought, certain states like California, for example, clinical professionals, RNs, NPs, MDs, they have to be W-2 employees. That's just something that is a requirement. In most other states, they don't necessarily have to be W-2 employees, but in any event, the practice entity itself should always be the one hiring clinical employees. So a lot of you are solo practitioners, you own your own business. A lot of you have management services organizations and you run through that model. Whichever side of the fence you might be on in that way, you just want to be sure that anyone clinical performing clinical services is hired by the practice entity. So the PC or the PLLC, the medical director's entity. Or if you're a solo practitioner, your entity, which means you wouldn't have to worry about that distinction as much. But those are really important things to keep in mind as well. Okay, compensation. This is kind of always the big hot topic that everybody wants to talk about during, employment and negotiations, of course. You want to be sure that your employees are being paid fair market value. And by fair market value, I mean that they're receiving pay that aligns with the education, schooling, and experience they have amassed, giving them the skills you're paying for. So, for example, you're not going to pay an RN $5 an hour to perform, IV hydration. That is just absurdly low and probably, I guess that's probably not even legal anywhere. I don't know what the minimum wage is across all the states, but it's definitely higher than that. And on the other hand, you're not going to pay an NP on staff, $50,000 a month. That's outrageous. That gives kind of this indicia that something maybe not be fully above board in the background. So just be sure that what you're paying and that the money you're paying to your employees, you're getting that value of services in exchange for that. Be careful about things like percentage-based pay. So in most states, you have to worry about not only corporate practice of medicine and nursing, but you also have to worry about impermissible fee splitting rules. In many states, it would not be permissible for an esthetician, for example, to earn commission off of medium to deep depth chemical peels, because those are typically considered medical. This doesn't apply in every state, but that is pretty much the majority of states are going to kind of scrutinize percentage-based compensation. The best way to go is either give somebody a flat hourly fee or a flat like annual salary. You can also offer performance-based bonuses that are based on things like clients seen in a specific amount of time, client satisfaction, things like that. What you never want to do is tie compensation directly to the amount of patients coming in the door. You always want to have the compensation structured in a way that nobody would look at it and say, oh, the more they bring in, the more they make, therefore they're shoveling these patients through just way too quickly. The concern there is that the quality of care is being compromised. So just make sure, again, that you are permitted to pay your employees the way they are being paid and that they're being paid a fair market wage for those services. So we talked about this up at the beginning. Really important that you have a contract in place ahead of time. And one thing I always try to remember myself about contracts is they're not there just to be a tool in a battle. They're also there to help answer questions that we might have, that your employer might have. Well, I don't know. Do I offer this benefit? Let's go back and look at your employment agreement. Oh, okay. I see. I did say I would give you this amount of raise on this date. Let's do that. There are lots of reasons why having a contract is helpful operationally. But again, the most important thing that a contract can do for you is protect your rights in the event that there's an actual legal dispute, which can come out of nowhere. It's unfortunate, but in the world we live in, people's families will turn on each other sometimes when are issues like this. So it's just good to have a contract that has already done the hard work for you. Like, hey, you signed this when we got together and this shouldn't be a surprise to you, kind of thing. It's just important to have those things in line. Again, your contract should include like the duties of that job, their requirement to comply with certain things. If you're going to have drug testing policies, it should indicate that that's going to be something the employee will be subject to. You want to think carefully through all of the things that you would want if you were the employee and then make sure that as the employer, you're being fair but protecting yourself. And employment agreements are something that we regularly draft for our clients. And, we very much think that the best business relationships come from a place where you're starting out on equal footing. And we want to foster that. We want everybody to feel like they're taken care of on both sides. But if our goal is to protect you, part of that means putting this very good, strong contract into place. Okay, this is like your internal documentation. So envision if you have an HR department or if you don't envision one, all of the forms and things that you would have to fill out when you come on as an employee or things you might need to do through the year to certify certain things. Those are all things that you should have in your space. So an employee handbook, we've all received those. They're usually a couple hundred pages long and they cover every policy and procedure for the job. You should have those on hand. Even if you just have one employee, it's not necessarily a legal requirement, but it's bonus points. So that's something I always like to ask clients to think about when we're talking through these things. In the event that a board inspected you or investigated you, you can pass with a C. Sure, a B plus would be better, but wouldn't it be great to pass with an A plus? That's where these extra credit points come in, these bonus points. So having things on hand like an employment or an employee handbook, even if you only have one or two employees, that looks good. That shows due diligence that you are going above and beyond to make sure everyone's on the same page and doing things correctly. So you want to have employees review those handbooks upon onboarding and sign something saying they did. And then again, once a year is a good idea to have them do that again. And you should revisit your policies and procedures yearly too, to determine, do we need to change anything? Do we have any policies that just aren't working out well? Hey, I heard about this law that changed that requires a certain number of break hours to be given to employees in New York City. Those are the kinds of things you'll want to respond to in your employee handbooks. So that's a great thing to have on hand. Training and certification documentation. The more training, the better, and that's clinical and administrative positions. The more highly trained your staff is, the better you're going to do. If you do have trained individuals, you want to keep those, certifications or documents or just logs that they have completed certain trainings and keep those on hand. Clinical protocols, really, really important. So, these are also often known as standard operating procedures, things like that. Basically, your clinical protocols for every service you have, it talks about the clinical considerations, contraindications, side effects. Usually will tell you how to do it. What's the technique? What's the process? At this clinic, how do we store these drugs or these supplies? Those are all things that should be in your clinical protocols. Those protocols should be reviewed and approved by your medical director, and every clinical employee should review them and sign off that they have done so. And those should be in your space and available to employees at all times. One of the first things that a regulatory board will ask for if they open an investigation into you is your clinical protocols. Guaranteed, that is always a part of the request. So it's good to have those in place. Supervision and oversight. Okay, so I think we all know that, and we've discussed on this call, a lot of times practitioners, no matter how experienced and skilled they may be, still require supervision, whether that's on-site supervision versus a virtual type supervision. You still have a lot of employees who are going to have some sort of collaborative arrangement with a physician. So whether these are your RNs or your PAs, that you're going to want to have a supervision agreement in where the medical director is essentially saying, I am taking responsibility for the things that this individual does, just like any other supervision agreement that you would like that would occur in these scenarios. There'd be no difference within your space. It's just that we would have a document saying this medical director is overseeing and supervising this clinician. They have agreed to what things this clinician is permitted to do pursuant to this supervision. Those agreements should include things like every quarter, the medical director must review 30% of physician assistants charts or something of that nature. You just want to make sure that those agreements in place and that supervision is actually happening. By that, I don't mean that, in most cases, you don't need an MD staring over somebody's shoulder as they inject filler. But in some cases, you might, just depends on your state and your level of expertise. But importantly, you should be sure that your supervisees and supervisors are communicating regularly and that the supervisor's keeping tabs on what's going on. That's really, really important. And documenting that kind of thing is really important. Training and scope. So we talked about this briefly a minute ago. The better trained you are, the better you are. And when, you have, this is another place again where like the bonus points come in. So somebody graduates from nursing school and then they get their license. They're legally cleared to now perform nursing. But Nursing is a big field. You might be great in the emergency department and have absolutely no idea how to do PDO threads. There are these things that there's got to be, you've got to be sure that they are trained specifically to your services. It's not necessarily a requirement in all states. Some states it is, not all states. But again, this is another area where you can get these bonus points. And also, the more highly trained your staff is, the more you can promote that kind of thing. The more confidence your clients are going to have that things will be done correctly. So the more training you have, the better. And again, keep documentation of training on hand. Make sure that anybody who is being trained within their scope of practice and not above it or below it. And make sure that the supervisor and the supervisee have parity in their knowledge. So maybe you have a great medical director. They're not necessarily in aesthetics, but they're family practitioners. So they're an internal medicine doc. So they kind of cover all bases in some ways. Get them a training, pay for them to have an injector course or a course on lasers or whatever it is you have them doing. Put that in your files. All of those things support the kind of the wall of compliance you're building around yourself.
Any kind of continuing education, any kind of certifications that they have as well, keep all of those on file. If you have any kind of regulatory board come and check, they're going to want to see this as well to ensure that your staff are well trained and they're making sure that everything is above board. So just make sure that you have all of that documentation and you should be good.
So again, kind of recapping what we've talked about, you know, do a background check. And in healthcare, that goes above and beyond the background check that you submit when you're getting your first job out of college. You know what I mean? Like when it comes to healthcare, it's not just about the criminal background check and the credit check. It's about their license, their licensure check. Get online, social media, do a little searching. Of course, you cannot believe everything you see or hear online, but you use your reasonable judgment to dig a little deeper into their backgrounds. Make sure that you're hiring a clinical staff correctly. So whether that's maybe you're in a state where everybody has to be a W-2 employee of a practice entity. Maybe you're in a state where they could be an independent contractor hired by a management services organization. Just be sure that your state permits the way that you are employing individuals or contracting with individuals. Make sure that the appropriate entity holds that employment contract. Document supervision, training, and protocols. This all ties back to the scope of practice aspect that we talked about. Just make sure that the person doing the job knows what they're doing, they're allowed to do it, and that somebody's checking in on them if required. And then document all of that. Make sure that you have documentation that this supervision arrangement isn't just on paper, it's actually happening in real time. Don't go on verbal agreements or handshake deals. That again, we see that a lot, and it's I'm trying to reemphasize that it's not just about I want this contract to be strong so that if we ever get in a fight, I can protect myself. It's also about we need a rule book here. We need a playbook to go by. And so an employment contract is just that. It's really important to have those in writing, especially when it comes to these other concepts we talked about, like non-competition and this and that. If you don't have a signed agreement, it's going to be really hard to hold somebody to a non-competition arrangement that you talked about verbally if they try to run off down the street and go to a competitor. So you want those things in writing. And then again, the misclassification of employee versus independent contractor, that is really important, not just from a healthcare law standpoint, but just in general for employment law purposes, but also just for running your business smoothly. An issue with improper classification can cost a ton of money and a ton of time to get through. So this is one of those things that could really cause a major bog down in your operations if it's not done appropriately. And all the things we touched on today, of course, we can help you with. We do help clients with every day. So any of these things, whether it's documentation, whether it's determining scope of practice, whether it's determining is this person W-2 or are they an independent contractor? Should I make a switch? These are all things that we can assist you with if you need help navigating those kinds of issues. But these are all good things to keep on hand. Make yourself a checklist or ask us to make you a checklist. And whenever you're onboarding anybody, just make sure you tick through all these boxes. And Kate read my mind, legal hiring checklist. So this is available to those of you. I believe we upload these presentations for the members. So there's your 60-second audit. Love that. And it's true. Just make sure that you've hit all those points, when you're going through the onboarding process, or even if you're just evaluating your current staffing setup.
And then from here, we are just going to go into a quick Q&A. We've really enjoyed having you guys join us today. I'm really happy that Mallory had taken the time to share her knowledge, and she really is a foundation of so much insight, and she knows what she's talking about. If you have any questions, she's a great person to ask them to, and she can help with pretty much any problem that you come to her with. So someone asked, I have a candidate that works as a concierge aesthetic injector. She told me that for non-compete clause only related to the concierge part. Should I trust her?
So let me understand. So you're saying she said she had a non-competition obligation, but it only applied to concierge services. So like, for example, she wouldn't be allowed to work for you and go to someone's home, but she might be able to work within your med spa. Is that what you're getting at, or is that what you're kind of saying? Because that's kind of what we're looking at right here. So usually a non-competition agreement is tailored specific to the services. And sometimes because a lot of people are performing such a broad array of services, it's unfair for an employer to say you can't provide any of these services anywhere else in this town. What if it's a small town and they live 30 minutes away from the next place they could be working? So a lot of times people will carve that out. They'll say you can go and perform aesthetics once you leave us. You just can't do the concierge aesthetics. Um, I tend to think never take anybody on their word, not because I think that somebody's being untruthful, but because they might not understand the obligation that they are subject to. Like they might not fully understand the full reach of that. Like maybe she thinks it applies to just concierge services, but maybe there's other language in there that broadens it. So what we would do is we would take a look at, we would want her to provide us with that contract or the agreement or whatever she's basing it on, she or he or they, excuse me, whatever they're basing it on. And then we would take a look at that and tell you, are you safe to have her performing XYZ?
And someone else had asked, would you include an NDA in the employment contracts?
Yeah, so you can, I mean, we always do include non-confidentiality disclosure. So that's the same thing as an NDA. Usually an NDA, a non-disclosure agreement, is a standalone agreement, but we incorporate those into the agreements we draft, and you should too. You definitely want to have something that says, and confidentiality agreements don't have to be limited temporally or geographically. You could say basically any of our proprietary information and confidential information that you come across while you work for us, you can't tell anybody that ever. And if you do, we'll sue you. So yeah, we always want to put those in there because they could take all of your methods, your techniques, little, tricks of the trade that you know that not everybody else knows, and then go down the street and give the benefit of all that hard work to someone else.
And I think that pretty much wraps up the questions that we have for the rest of the webinar. So I just want to say again, thank you to everyone for joining us. If you have any questions, feel free to reach out to us. Like I said, you can reach out to me directly. My email is Kate with a C and then Holiday, HOLLIDAY at lengealaw.com. If you have any questions, reach out to me. You can also reach out to Mallory, but thank you again for being a valued Lengea member. We really appreciate you, and we appreciate you taking the time to spend with us today to learn a little bit more about how to compliantly protect your business and do your hiring in a way that really supports you in the long term. Our favorite quote is that prevention is cheaper than correction. It's like Botox. You're going to spend a lot less money to make it right in the first place rather than trying to fix everything that went wrong down the road. So that's our favorite thing to say, and it really rings true every time.
Been there, done that with Botox before. Not fun.
No,
Not
I'm
having the Joker's smile for 2 months. So, yeah, that's a great point, Kate. Thank you. Thank you, everyone. Have a wonderful evening, and we'll see you next time.
Thank you so much, guys. Have a great rest of your night.